The Supreme Court will leave a Texas abortion law in effect, but allow for abortion providers to continue challenging the law. Texas has one of the most restrictive abortion laws in the country. The procedure is banned after about 6 weeks, a time before many women know they are pregnant. It also delegates enforcement of the law to private citizens, allowing anyone to sue providers or others who aid in the procedure. Today's ruling means the law will stay in place while providers challenge how the law is enforced in lower courts. For more on this, I want to bring in CBS News chief legal correspondent Jan Crawford. Hi, Jan. So first off, I want to get your reaction to the Supreme Court's ruling. Was this expected, or were you at all surprised?
You know, I think after the arguments, it seemed like it was going to be very difficult for the court to issue any kind of broad ruling that allowed the Biden administration to go forward with its challenges, or even the providers in a more sweeping way that they were hoping to, because they would have had to completely upend our understandings of the role of the state and federal courts and how they work together. I mean, I guess what, Tanya, I was most surprised by was that they took up this case in the first place in this early pre-enforcement stage before anyone's even been sued under this law for violating it. And now, as we see today, I mean, it was really just a waste of time. The court has just kicked the can down the road in this opinion, and they're going to have to deal with it at some point in the future again.
But, Jan, they are saying that providers can go forward with legal challenges, correct? I mean, on the one hand, they could have just fully stopped the legal proceedings right here, correct?
They could have, and they basically did, because they said the providers can only sue a very narrow group of defendants, like state licensing officials. They can't sue state court judges to prevent them enforcing it. They can't sue county clerks to prevent them from docketing the case. So they can't stop any of the lawsuits. The providers can't now under this ruling today. They can only sue this, really small group of defendants that don't really have that much power anyway. So it's kind of like, I mean, you want to talk about a hollow victory. I mean, that's not a lot there for the providers. Their focus will be and should be in the state courts, and that's where all the action is happening. And I think today the takeaway is the Supreme Court saying you can try, but really this is really going to get solved in the state courts, this state law issue.
And what were the actual arguments that the providers brought to the Supreme Court in this case?
So, I think it's important to keep in mind that this case is not about the right to abortion. It's not about whether to overturn Roe versus Wade. That's another case that they just heard arguments on about a Mississippi 15-week ban. This case is purely procedural. It's super complicated and it's super complex because this is a very unique law. And Texas officials wrote it that way on purpose to try to keep people from suing to block it before it actually gets enforced. So They said, the state officials, we're not going to enforce it. We just have the ban on the books. And hey, but you private parties, y'all can go out there and sue and get $10,000 if you win in civil court. So I think that's what's really important to keep in mind. Now, be that as it may, and this is this unique law, the Biden administration tried to jump in to challenge it. The abortion providers had already sued back in July, and they were trying to keep that case going. And the bulk of their argument solely was that this is a constitutional right to abortion, the state law infringes it, and they can't do an end run around, our ability to sue to challenge it by saying, oh, we're not enforcing it, we're leaving it to these private parties, that was nullification of constitutional rights that were enshrined in the federal Constitution.
And so what is the status of the Biden administration's challenge of this Texas law?
Done. They're out. The court said in a separate opinion today that they were dismissing that case as improvidently granted, which means the court is saying we never should have taken the Biden administration's lawsuit challenge to begin with. So they can try to find other grounds. I don't know how, but right now they're out.
So essentially you are saying the abortion providers in Texas have no further recourse right now except to go back to Texas and sue insurers, you said? I just want to clarify.
The license, like state licensing boards. It's and they're going to do that. I mean, they'll go back to a federal district court judge. They'll ask him to stop this law, and he very well may say, like, all right, I'm going to put it on hold while these legal challenges wind down. Well, then Texas is going to go to the Federal Court of Appeals, just like they did the last time, and say that they can't do this. And the appeals court, just like they did the last time, is probably going to say, you're right, we're keeping the ban in place. And then that will then come right back to the Supreme Court. So the court's going to have to deal with this once it goes through these little hoops again. But I think that was intentional, too. They're kicking the can down the road because they know they have this Mississippi case. So whenever this Texas case gets back to the Supreme Court, they're just going to hold off on deciding it until they know what the decision is going to be in the Mississippi case. So we may not have an issue on an answer on either one of these cases until sometime in the summer, in June.
So a huge blow for the Texas abortion providers, but the story is not over yet. That's basically
it's a glimmer. I would say you could say the Supreme Court gave them a glimmer of hope, right?
Mm-hmm.
A glimmer of hope, but only a very slight glimmer. Yeah.
All right. Well, Jan Crawford in Washington, thank you so much for your insight. We appreciate it.
Sure.